Derek Chauvin, this was day 2 of his trial, and the court started jury selection today, which was a little bit surprising to me. Now, they said that they were going to do that, but I was sort of under the impression that maybe we might hear from the Court of Appeals or the Supreme Court there in Minnesota that would do something to rock the boat a little bit, but that is not happening. It's not happening. Nobody from the Court of Appeals or the Supreme Court has said anything. And so this judge, Judge Peter Cahill, is trucking along, and we actually got 3 of 12 jurors seated today, which was kind of a big surprise to me. But that is a good thing. That means this thing is on the tracks. They're moving forward. Nobody's telling them to stop thus far. So we can just presume that it's going to continue forward. And so let me give you the outline of what the current field looks like. So this is a diagram where we've got on the right side, we've got the defense team, and we learn, you see there are new faces here than there were yesterday. We still have the judge. Today he took his mask off, so we have a better picture of him. Same with Eric Nelson, Matthew Frank also. So Eric Nelson is the defense lawyer who's representing Derek Chauvin over here on the defense side. We also learned that Eric Nelson has an assistant. Don't know her name just yet, but she was in the back of the courtroom helping with jury selection. Jury selection is sort of a big task. You're consuming a ton of information very rapidly. And typically, if you're an attorney, you need somebody to help with writing down the information. You're listening, watching body language, and you need somebody else to help digest that information for you. And so Eric Nelson, the defense attorney, had his assistant there. We don't know her name yet, but she's there in the courtroom. On the prosecution, we have an appearance of several other people today. Yesterday, we saw the assistant attorney general, Matthew Frank, who was really leading the case. Then today, we saw this new guy, Sandeep Iyer, and this other guy, Steve Schleicher, were also speaking today on behalf of the government. We learned that they also have assistants. So this woman here was in court, and this gentleman here was also in court, but we didn't get their names yet, so we just don't know exactly who they are. So we're going to go through a couple of the motions in limine, but then we're going to talk about this jury selection. And so now today we know that we have 3 of the 12 jurors who have been seated, and we're going to break down what that looks like. But before we get there, a couple issues that I wanted to pause on as it relates to the motions in limine. And so motions in limine are very important. These are dictating what the rules of the trial are. Now, a lot of people are just sort of watching this stuff, and they're saying, oh, it's just pre-trial, boring, mumbo jumbo. No, this is where trials are made and broken. Here when the rules are outlined. And so these are some very, very important issues that I think are being settled right now that a lot of people in the media are just glossing over. Everybody's talking about the jurors. Oh my God, there's a white guy on the jury. Oh my God, there's a lady of color on the jury. Okay, so we got that. We're going to do that analysis also, right? Can't get away without commenting on any of that. So we are going to get there, but a lot of this stuff was pretty powerful that took place earlier on today in the pretrial discussions on motions in limine, dictating what the rules are. If you pass go, do you collect $200? Yes or no? The judge is going to decide what the rules are in his particular courtroom. And so we start off with this segment from the defense attorney, Eric Nelson, who is talking about training versus policy. Okay, now this is sort of a in the weeds conversation about this, but last night on Clubhouse, we were diving into this. What if the policy manual for the Minneapolis Police Department says that you can put a knee on somebody's back? And I think Timcast and some other streams, other YouTubers were showing you policies from the Minneapolis Police Department that said very clearly that you can put a knee on somebody's neck or on their back, or you can use it as a brace to hold somebody against the ground when you're trying to detain them. And we've covered some of this previously. We talked about this on this channel. I found a CNN article that said, yeah, the knee restraints are allowed. Those are permissible. But we also had some questions about it. I went to go find the policy myself, and lo and behold, they were off of Minneapolis Police Department's website. A lot of revisions. The new documents now say, yeah, absolutely nothing to do with the knee on the neck, nothing at all. They just scrubbed it clean. And so now what they're talking about in court is, of those issues that I just sort of dumped out there on you, what of those can we discuss? What can we bring up in front of court or in front of the jury? And so the judge is going in here and talking about kind of 2 different things. The defense attorney and the prosecutor, so the government and Chauvin's attorney, they're duking it out over, well, what if the formal policy says this? Then can we talk about it? Or what if the policy says that? And what if the policy was changed after George Floyd died? Can we talk about those policies? Can we talk about the fact that the government modified their policies? And neither side really wants to talk about that. The government doesn't want to talk about it. The defense doesn't want to talk about it. And the reason, I think, in my opinion, why, is if the defense if the jury knows that the defense is concerned that they changed their policies, well, that might show that their client did something wrong and they were sort of in violation of a policy. Even though the policy wasn't in effect at the time, it still tends to show that maybe what happened was in fact bad because they changed the policy, right? It's like, you know, if you ever see a warning label on anything, okay, usually that warning label didn't exist until somebody tried that thing. Okay, when you know, it says here, don't eat this corkscrew. Do you think that they were just bored and put that warning on that? No, somebody tried to eat that corkscrew. That's why they put it on there. So here they're saying, well, they changed the policy. That means that something bad happened previously. So the defense does not want that in. Similarly, the government doesn't want it in because if they're allowed to talk about a policy that allows the knee on the neck, well, then the defense can say, see, it's policy. He easily could do it. So the prosecutor doesn't want that in. The defense attorney doesn't want it in. So they kept all of that out. Now they're having a conversation about training. So the judge, really, to his credit, I think he's doing a great job thus far, is saying that, well, we're not really going to care much about the policies, whether it changed, whether it happened before, whatever. We're going to go right back to the training and experience. If they got training, then they're going to be allowed to talk about the training they received. But they're also not allowed to comment on certain other things. So let's get into it. There's an interesting little snippet here. You're going to hear somebody from the government is now saying that Chauvin, they're using Chauvin's name. They're saying Chauvin and Chauvin and Chauvin. And the judge says, whoa, hey, it's Mr. Chauvin, all right? It's Mr. Chauvin. We use titles in this courtroom, so the judge gets a little bit snippety with him, which is always fun when the government is snippety at the prosecutor. So let's dive into this first clip. Here is Eric Nelson, and here it is.
Yes, identify yourself for the record, please.
This is Sunny Byer for the state of Minnesota. There is one objection we have to the Chauvin's motion 19. The state opposes the motion to the extent it precludes testimony not just on subsequent changes to MPD policies, which we agree absolutely should be excluded, but also on MPD policies on which Chauvin was trained, but that might not have been in effect at the time of Floyd's death. Policies on which Chauvin was trained are definitely relevant.
It's Mr. Chauvin, please.
Whether Chauvin had the requisite mental...
Mr. Iyer? Mr. Iyer? We refer to everyone by title, so it's Mr. Chauvin, please.
Oh, my apologies, Your Honor. So this court recognized that whether Mr. Chauvin was trained on a particular policy is relevant in determining whether he had the requisite mens rea, and it recognized as much in the probable cause order.
All right, so that's part of the video. That's normal.
Follow training would be potentially prohibitive, for example, of a gross deviation from the standard of care, of whether he consciously took a chance of causing death or great bodily harm, and of potential recklessness. And so for that reason, the state respectfully asks that the court deny the motion to the extent it seeks exclusion of training Mr. Chauvin received that might not be reflected in the MPD policies that were in effect at the time of Mr. Floyd's death.
So what I hear you saying is it was not policy, but they were training on a certain topic. Mr. Chauvin received that training, and you want to be able to comment on that even though it was not firmly in policy yet.
That's correct, Your Honor.
Mr. Nelson.
I'm trying to figure out if you're talking to me or him. Sorry, this is an awkward arrangement.
True.
Because I see 1, 2, 3, 4, 5, 6 of 7, 8. So I apologize, Your Honor. I'm not trying to be glib. It's just
no, actually, I'll address you specifically if I need to. Mr. Iyer, is that kind of what you're saying?
Yes, Your Honor, it is.
Okay, Mr. Nelson, do you have...
Yes, Your Honor. In terms of training through the Minneapolis Police Department, that's obviously going to be a significant issue throughout the course of Mr. Chauvin's career. What our motion specifically was addressing is any policy changes subsequent to the incident at question here. We are in agreement that those policies, I think we're both in agreement that those policies should not be referenced during the course of the trial, those changes. With respect to his other training, I guess I would seek clarification from counsel simply because there are training methods that have been approved. If we're talking policy versus training, I guess that's the question that I would have.
All right. You are, Mr. Iyer, you are essentially trying to get in the training that he had. I don't see any reason why that would not be relevant. I think that comes in, regardless of whether it's been embedded in policy or not. So I think we can probably deal with this when it comes up, drawing the lines on appropriate testimony. But if it's training Mr. Chauvin received before the death of Mr. Floyd, I think we have to recognize that that is relevant, and I would allow it, regardless of policy. All right. Does that answer the question, Mr. Iyer?
Yes, it does. Thank you, Your Honor.
All right. And the next.
All right. So that was really in the weeds. I know not the most interesting clip, but it is important because they're having conversations about what can come into court as it relates to the policies. And I think this is a pretty important distinction. When we talked about this as one of the key defenses, specifically in my defending Derek Chauvin, defending the indefensible. And that was really based around the premise that, you know, the government here has to prove that this was imminently dangerous. And if they're going to go into the third-degree murder charge, that there was culpable negligence and all of these other things. I may have those flip-flopped. But the point is they've got to prove the evidence. It's their burden to prove it. And so I was saying that one of the defense attorney's options would be to show it's not dangerous. It's not eminently dangerous. It's not culpable negligence. Why? Because it's a part of the policy. It's a part of the manual. And it sounds like that may or may not come in based on the testimony that is presented in front of the court. So the judge is saying, well, we're gonna kind of deal with that when it comes in front of us. Of course, we're going to be able to talk about the training, because that person received the training and it's relevant to their testimony. If they were trained a certain way and they're trained to put a knee on the neck, then, well, the policy doesn't really matter, because it's that first person account. It's their personal testimony, and they're subject to cross-examination. So I think the judge did a very nice thing here for both sides. And he said, well, we're not going to bicker about the policy stuff. We're just going to talk about the witnesses' firsthand experience, what they received in regards to training in court. And it was a pretty uneventful discussion there. Both the defense and I think the prosecutor, neither one of them really got what they wanted. And the judge said, well, we'll just deal with it when it comes up. And I think it was sort of the first hint that this judge is pretty fair, pretty even-handed to both sides of this. Didn't see much here. Now, who was that other guy who popped into frame on Zoom? Hadn't seen him before or heard about him. And looking into him a little bit, he's this guy. He's actually a private attorney. Goes by the name of Sandeep Iyer, or Ear, something like that. And he's a senior associate over from New York in Washington, D.C. with this firm called Hogan Lovells. And so he is not an actual prosecutor. He's somebody who focuses on appellate litigation and dispositive motions in federal and state court. He's briefed numerous cases before the U.S. Supreme Court. You can see sharp guy, went to Yale Law School, went to Harvard undergrad, admitted in New York, D.C., and Maryland, multiple court admissions to different appeals courts. And he's in the litigation, arbitration, and employment division at this private law firm. And so he's just working on this case sort of independently of what he does for his day job. In 2014, he also received some sort of a scholarship or a fellowship awarded to support work towards a JD in law at Yale University. Received this over from the Paul and Daisy Soros Fellowship for New Americans. Don't know if that has anything to do with George Soros, but this guy, born in Jersey, son of Indian immigrants, came to America in the 70s, and he graduated from Harvard, and on and on and on. Now he's studying for JD. So he looks like he graduated from from Yale in 2016, Harvard in 2011. So smart guy, and he's on the government's team moving forward. So that's the latest new addition. Now let's go back and let's talk about another motion in limine. This is very interesting as well. So this motion, I think, if I can recall correctly, was submitted by the defense. So now the defense, Derek Chauvin's defense team, wants to make sure that other officers who were there can't speculate or can't comment about what they would have done. Okay, so we know that Derek Chauvin had his knee on the back of George Floyd's neck. There were many other officers there. There were the three others who got actually charged with crimes, but there were other officers who were sort of arriving after the scene. Paramedics were there after the original incident. Once the paramedics get there and George Floyd is carted off back into the back of an ambulance, we see many other officers there beyond the original four. And so what the defense attorneys are saying here is, look, you can call these witnesses, but these officers cannot speculate about what they would have done or give an opinion on what Derek Chauvin was doing. And you might say, well, that's kind of weird. If you're going to call a fellow officer onto the stand, wouldn't a pertinent question be to, hey, what do you think? Was that murder or not? Did he kill him or not? What would you have done in that situation? And so the defense certainly doesn't want that to happen, because if five officers got up there and said, yeah, what Derek Chauvin did was inappropriate, and I wouldn't have used that same amount of force, not so good for the defense. So they want to make sure that this sort of testimony is nipped in the bud so that it can't be allowed to happen. And the judge kind of agrees with that. The prosecutor, not so much. Let's listen in and see what the judge has to say to sort this out.
Just because someone has received training and then in hindsight wants to give their opinion, that's not appropriate. You have experts on the training. And for example, a training officer can talk about it because they have the expertise. But hindsight observations of, I just put up the crime tape, but let me tell you what I would think about, that's not going to be allowed. So to that extent, the defense motion is granted. This does not limit expert witnesses to talk about whether the use of force by Mr. Chauvin or other officers on the scene on Mr. Floyd was reasonable or not. So experts, and even the training officers, I think, qualify as experts as to whether or not that was an appropriate use of force according to how they train. That would be allowed. All right?
Thank you. Then,
all right, so the defense actually won that one. I think the judge is saying that yes, officers can't come up. They can't put up the crime tape and say, oh, this is all cordoned off, and then give an opinion about what happened, because they're just lay witnesses. They're not firsthand knowledge. They don't have a firsthand account of anything that took place there. So it would just be sort of speculative opinion if another cop just sort of took the stand and said, yeah, I think that was wrong. It's too speculative. But the judge does say, well, expert witnesses, they can testify, of course. If somebody is watching the scene after the fact, they are qualified as an expert. They have gone through additional schooling, training, certifications, credentialing, whatever that is, and they are now allowed to give testimony about that because they've been certified as an expert. But he also goes to say that other officers who are training officers who would qualify as an expert witness. So in other words, if Derek Chauvin had a supervisor who taught him regularly how to train or how to subdue prospective suspects, then that officer could come in and give an opinion about whether he used excessive force or whether what he did was outside of the policy, because that person is credentialed to comment on that. But the other officers are not. They're just lay people, so they cannot give their opinion on that. And so that is sort of narrowing for the defense, for Derek Chauvin, some of the allowable testimony, which serves the defense. So the judge agreed with the defense on that motion. We have another motion in limine before we get into jury selection. You may remember this scene from the body camera footage that was released. I want to thank Jeremy Matrita over on locals.com for posting this. Made it very easy for me to scrub back through this video. Thank you, Jeremy. And what we see here is this is the scene from the side of the road. George Floyd is, of course, under this officer, under his body. You can see he's not in the frame. You can't see George Floyd's body here, but he's laying down right now. There are a lot of other individuals sort of on the right side of this photo shouting at the officers from the sidewalk. And this woman comes walking across the street, and you can hear her saying something like, it's hard to make out, but basically she's shouting at the officers, you're killing him, check his pulse. And it turns out she's a firefighter. She's somebody who knows how to identify people who need help, who has the capability, the medical credentials to resuscitate people and all of those other things. And so now they're saying, well, what can she say? So they're trying to hash out these rules and talk about what she is allowed and not allowed to say. And you may be asking yourself, well, what do you mean? She can talk about whatever she wants. But what about if she says something like, I could have saved him. If you would have let me there, I could have saved him. Whoa, that's pretty volatile. Is she qualified to make that statement? Let's see what the judge has to say.
Back to number 21, the defense is seeking an order precluding a witness named Genevieve Hansen, who is a Minneapolis firefighter who was present at the scene, from offering speculative testimony that her intervention would have saved his life or could have saved his life. Ultimately, Your Honor, while we certainly understand that Ms. Hansen has certain qualifications, she's a Minneapolis firefighter, she's certainly trained in things of CPR, she may have experience in various regards. However, in this particular incident, our position is that her testimony or her opining that had she been able to intervene would have saved her life is just simply too speculative. Certainly the cause of Mr. Floyd's death is of great controversy in this case, and while she may be certified to perform CPR, she is not a forensic pathologist, she is not a physician of any nature, and whether or not Mr. Floyd's death was preventable had she been able to intervene would simply be speculative.
Does the state intend on offering that specific narrow opinion?
Real quick, so Ms. Faith just mentioned that the audio is low. I know it's low. It's not on my end. You can see here, even on, so the court right now, they're trying to hash out some of their tech. But if you look over here, you can see that even their volume's low. Look down here, on the green knob. I mean, they're basically like at 30% volume. So it's really hard to hear. I know that. I apologize for that. At the end of the show for the podcasters, I will try to beef up the volume on the court audio, but just generally speaking, it was low audio all day, which was a little bit frustrating. But so listen intently. Tell everyone around you to pipe down for a minute so you can listen to this trial. Here it is.
Ms. Hansen could have saved Mr. Floyd.
We don't intend to offer the opinion that Ms. Hansen could have saved Mr. Floyd. What we intend to offer is her belief at the time of the incident that if she intervened, she could have saved Mr. Floyd. And the reason why that's important is because the state intends to call Ms. Hansen to speak to what she saw on the scene through the lens of her own perception and to explain the comments she made to the officers and the actions that she took on the scene. And part of that opinion, as is true with any lay witness, is shaped by her own personal experience. And in Ms. Hansen's case, because she's a firefighter, she's handled many medical calls, including calls regarding individuals who are unconscious. And so when she got to the scene, she saw that Mr. Floyd was breathing, but his breathing was heavily labored. And so based on her own personal experiences, she immediately called for the officers to check Floyd's pulse, repeated that plea over and over, and soon asked them to begin chest compressions on Mr. Floyd. And so we're only offering her narrow belief that if she was able to intervene, or if someone had intervened, they could have saved Mr. Floyd, in order to explain her observations during the course of the incident. And that's classic Rule 701 testimony. It's based on her observations at the scene and her own personal experiences and personal knowledge. And it's helpful to the trier fact to understand Ms. Hansen's testimony and to understand what Ms. Hansen was saying at the scene.
I'm going to grant the defense motion to this extent. Ms. Hansen can describe what she saw. She can describe her training and experience. She can describe what she felt was indications that Mr. Floyd was in medical distress. She can indicate that she thought that at that time she thought medical intervention should have been started, because these are the things that she always does in the field. I assume as a firefighter, she goes to the scene, she sees somebody is in medical distress, and ultimately are in need of medical intervention. So she can testify to all that, and that explains her testimony. But to get to the point to make a medical testimony that she actually could have saved him is a medical testimony that she does not have the expertise, since she does not know all the other factors that are going into that. But she can say almost everything right up to that. The opinion that I could have saved him is not a proper opinion for her to testify to, but everything up to that and why she thought medical intervention was required urgently because of what she saw is certainly permissible.
Agreed, Your Honor.
So that's the court's ruling.
Yeah, and I think that's a good ruling. I think that makes a lot of sense. It's another win for the defense, but it's the right call, in my opinion. You know, she is somebody who can, as the judge said, so because the audio is low, I'll do a quick recap here. But the judge, the argument here, Genevieve Hansen was somebody who was responding to the scene. She's a firefighter. She's obviously helped treat people who are in dire situations before. So the prosecutor in his argument was saying she should be able to testify on her a very limited basis that she could have saved him. And so this must have come out in pretrial interviews from both sides that she was going to testify this way, which is why the defense filed a motion to stop her from testifying that way, because she's not qualified to testify that way. The judge agrees that she can come up there and she can say, yeah, he looks like he's laboring, his breath is bad, he needs medical attention. She can come to those conclusions. Absolutely right. And so they can go walk all the way right up to that line. She can say that, but she cannot say that one specific phrase, I would have saved him or I could have saved him, because it's just way too speculative. And she doesn't know the full nature of the toxicology report or anything. She doesn't know anything. She could have administered aid, but not that conclusory statement that I could have saved him. Now, the prosecution, of course, wants that in because it basically shows, it magnifies the amount of negligence that the government through the police officers were responsible for. If there was a person standing there who could have saved George Floyd and they didn't do that, that doesn't look so good for their case. So the question is, well, could she have saved him? Maybe. Who knows? But she can't come to the conclusion. The judge agrees all the way up to that line, but can't cross it. So a little bit of a back and forth there. And the judge is going to kind of split it down the middle. Ultimately, I think the defense gets the point on that one, but the prosecution also can do a lot of damage with that conversation. They can say, yeah, there was a firefighter, an EMT, somebody medically trained standing right there. They can't say that she could have saved him, but they could say, for example, she could have provided medical attention to him, which is a powerful statement by itself. All right, so let's change gears. Let's talk about the jury selection now. Jury selection is very important part of the case. It can be very tedious, very boring, because you're sort of asking the same questions of every single juror that comes in. So the way that this format works is the judge will call in a big panel of people into the room. Actually, it wasn't that big. I think it was just maybe a dozen people. On the first round, when it's non-COVID time, oftentimes you'll pull in 30 people at the time and you'll say, hey, do you know anybody here? Can you recognize any of these witnesses? And you'll sort of ask questions of the entire panel. The people who have problems, they'll raise their number or whatever the format is. So here it was a smaller group of people. The judge asked them all questions, asked everybody to introduce themselves, all the attorneys, introduce yourselves to people. Okay, and then you call them up one by one, literally one by one. And the judge in private, away from the other jurors, and you ask them questions. And so we got through, I think 7 or 8 of them today. I don't recall. We have 3 people who made it onto the jury. They survived that line of questioning. And so let's go through this because it is interesting. We're going to be spending a lot of time with these people. So it's a good idea to get a good lay of the land as it relates to the jurors. So let's take a look at the rules first and foremost. In Minnesota, this comes from mncourts.gov. This is their jury information sheet. What does it tell us about juries in Minnesota? We have a grand jury, or we can have what's called a petite jury. which is used in civil and criminal trials. A criminal jury will consist of 12 people if the sentence for the crime charged is more than 1 year of confinement, which of course Derek Chauvin's will be. So we're looking at 12 jurors. 6 would be if it's a penalty of less than 1 year. These are according to the Minnesota rules. So that means we've got this panel to fill out. So this is the jury box. This is 12. The blue are going to be 12 people. So we've got 6 on the top, 6 on the bottom, sort of representing the jury box. Over here, I don't recall if the judge said he wanted 2 alternates or 4. I think he might have said 3 to 4 alternates. I don't know, or if he's limited to 2. So 2 of these may be going away. And we're going to have some alternates who are going to be a part of the panel, but not part of the decision. Remember that this trial does not even start until March 27th, really in full, but the jurors still need to be seated and they need to iron out some of the issues with the Court of Appeals and the Supreme Court and on and on and on. So they need to fill this panel, and they started that today. Let's take a look at some qualifications. Who needs to go on the jury panel? A person is qualified for jury service if he or she is 18 or older, if she is a citizen of the United States and a resident of Minnesota, and the person must be able to read or speak English, which we're going to see the first witness had some difficulties with this, or the first juror had some difficulties with this, and they must be physically and mentally capable of rendering jury service. Can't do it if you're completing parole, if you've not completed your sentence after a felony conviction or any of those other things. An eligible juror may be excused from jury service by the judge or jury commissioner if their ability to perform their jury duties is impaired or it would be an extreme hardship to them. Easily deterred. Okay, so those are the rules. First juror that we're going to listen to, this clip is a little bit long, but I wanted to play it out just so you can kind of see how monotonous this whole thing can be. So this woman is, my understanding is she is from Mexico. English is a second language. She's, a mom. She's got a bunch of kids, called into court, and she's kind of having a hard time communicating back and forth with the judge and the defense attorney here. And he's being very patient with her. He's trying to understand if she understands, because we're going to be hearing about a lot of medical stuff, things like asphyxiation and cause of death and toxicology reports and all that stuff, which is not necessarily an easy thing to understand if English is not your first language. You can talk about, how to do the routine things around your life, but if you're talking about, detailed medical information, then that might be something that is outside of your comfort zone as a language. And so we're going to see this conversation that's taking place back and forth between Eric Nelson and prospective juror number 1. And here that one is. Great.
So your first thought was, if I understand you correctly, is why me, right? Mm-hmm. Is that a yes, ma'am?
Yes.
Okay, thank you. As you were filling out the questionnaire, and it was asking you specific questions about this case and your perceptions about this case, did it concern you more because of the nature of this case versus other cases?
Yeah. Mm-hmm.
How so?
I say that case is just only I know because I saw on the TV. Right. I wasn't there.
Mm-hmm. Okay. So, I understand you weren't there, but does the profile of this case concern you?
Second?
She didn't understand.
So there are lots of, maybe I'll rephrase my question if that's okay. There are a lot of types of cases that come to court. Sometimes it may be someone steals something from a store, right? And nobody ever hears about it, mm-hmm. right? Mm-hmm. But this case has been in the news a lot. You would agree with that? Mm-hmm. Is there anything about the fact?
Yeah, sorry, yes.
Sorry. Is there any? But this case has been in the news quite a bit, right?
Yes. Mm-hmm.
Have you only seen one news story, or have you seen many news stories?
No, like I said, I'm so busy at work, and I'm housewife. And sometimes when I have time, I turn the TV and I saw and watch this case because just in the TV, every day.
Every day.
Mm-hmm, yeah.
And even since you filled out this questionnaire,
I had like they say, oh, why it has to do that, I mean.
So let me, because you're saying something I think very important here, and I want to make sure I understand. Okay, you saw some videos about what happened. Is that correct?
Yeah, the news.
On the news. So you saw a video that many people have seen of the arrest of Mr. Floyd.
Mm-hmm.
Yes.
That's second wing.
So did you see a video of Mr. Floyd being arrested by the Minneapolis Police Department?
Oh, yes. Uh-huh.
Yeah. And what I think you said is you had a reaction to that video. Would that be correct?
Yeah, I saw when that guy pulled his, leg or knee on that, so he can breathe.
Okay.
and he asking for.
And did you form an opinion about what you saw? Mm-hmm. Is that
Yes,
it?
yes.
Thank you. I'm sorry, it's very awkward. It's not like real life. What was the opinion that you formed when you saw that video?
My opinion is when he tell the guy I can breathe, and he still do that, you know. And I remember when I said another police around him, and I said, why don't say, hey, don't do that because he's gonna die. So I said, why? Just, you know, what I feel, that's not fair because we are humans, you know. And he said, hey, I can breathe. He was on top on him, so he doesn't. He can move. He was on top, so.
Okay. So your job, if you were to be selected as a juror in this case, would be to hear all of the evidence in this case.
Mm-hmm.
Do you understand that? Is that a yes?
Yes.
Okay. And you may see that video again in this trial. Do you understand that?
Yes.
But you may also hear or see other videos from different angles and different perspectives. Would you be okay with that?
Yes.
Okay. The question then becomes, if you see, are you willing, let me rephrase this, are you willing to examine all of the evidence to make a determination about this case?
Yes.
The opinion that you had before, when you first saw the video, would you be willing to change that opinion if you find other information out later?
Well, it's true, you know. Yes.
What is true?
It is true, whatever evidence. Mm-hmm.
So, again, we have to be very clear here, okay? Would you be willing to re-examine your opinion today if you see other evidence that change it? Would you allow it to change your mind?
Yes.
Okay, good. Now, I'm going to just ask you some more general questions, if that's okay. All right, just to learn a little bit more about you. Okay.
Okay.
So let's.
All right. So he goes on, and you can very clearly tell, in my opinion, that there's a language barrier there that just doesn't serve the interest of the trial. And they did a very nice job, very patient with her this morning, this afternoon, whenever she was up. And ultimately, she didn't make it on the panel. Right now, she had a difficult time communicating about just some of the basic things. He said, "Do you have is this different from a different profile of a different case?" And profile, what is that, right? And you can understand that if you're going to be asking medical expert witnesses about some concrete medical advice or some detailed language there, that she's going to have a difficult time communicating it. They were very patient, but ultimately she didn't make the cut. Here is another picture. So after they were going through and interviewing all of the prospective jurors, they would break after each juror and they would have conversations about it. So this is Eric Nelson. Then we have Derek Chauvin over here and their assistant. And so they're all communicating away from the microphones, back sort of hunched over this table to have conversations about what they want to do. Do they want to strike a juror? Do they want to strike a juror for cause? A peremptory strike, meaning that they can just strike them without cause. And so they're talking about it. And then we get on to juror number 3. We're not going to go through all, I think 7 or 8 of them, but this is the last of the people that we're going to cover that are not making the panel. This one's interesting. Juror number 3, very honest. Just comes out and says, "Listen, I can't be impartial. Are you kidding me? I saw the video. What are you, nuts? There's no way I'm changing my opinion." The judge and everybody are really trying to rehabilitate her, and she's just, no, it's not changing. I saw what I saw. Here is juror number 3.
Do you think you could put all that aside? Because, as you notice, we asked you, what have you read about or heard about the case? Because we recognize that people have heard about this case. Mm-hmm. The question becomes, can you decide the case only on what you hear in the courtroom?
So aside from what I've heard since my questionnaire, am I willing to put the headlines aside?
Everything you've heard before. Because you have to essentially be the blank slate, and it's okay to come in with some knowledge about the case. It's okay to even have opinions. It's even okay to have strong opinions about the case. But as a juror, you have to put all that aside. Some people will say, "No, I can't do that. I've got these very strong opinions. I cannot put them aside. I cannot be," and very honestly, say they can't be fair and impartial. Some people, even with strong opinions, can say, "I understand my role, and I feel I have the self-discipline to be able to do that, to put aside what I've heard before, decide just what we hear in court, and to follow the law," which obviously comes from the court. Mm-hmm.
Trying hard.
I think you could do that.
I definitely fall into the bucket of strong opinions.
Okay, and I noticed that on your questionnaire. Yeah, there were some.
Definitely have strong opinions about the case. I think I could try to be impartial. I don't know that I can promise impartiality just based on my opinions and personal experiences, I don't know that that could be promised.
Okay, and I appreciate that's a very honest answer. And we put you in a tough spot because we say, you know something about the case, but even what you know, we're asking you to put aside. And to some extent, can a bell be unrung? All those kind of concepts. And we put you in a tough spot and say, now tell us whether you can be fair and impartial. We recognize that that's a tough spot to put you in. But we actually, you know yourself better than any of us. Do you think when it comes right down to it, that you could do it?
I don't think so.
Okay. And tell me a little bit more about that.
I think in this case, there's very clear action that was taken, and I think regardless of what kind of dress you put the action in, it happened. And so regardless of what charges are brought or what evidence is brought, I think there's already too much that has happened and too much that is just cold hard fact that cannot be ignored.
Okay. So let me put it one last way. As a juror, you can't be hoping or yearning for a certain result over another. And because if you are, either way, you shouldn't be a juror because that's not being impartial. And it's not a character flaw, it's just, based on what you've seen and heard. And
Understood.
Yeah. So do you think that's still the case, that you probably...
I think I definitely hope for a specific outcome, and I don't know that that would change.
Okay. Any inquiry from the defense?
Nope.
Well, let me just see if the defense or the state has an inquiry. You may.
So we're not going to listen to the prosecutor. So the prosecutor comes back up. It's actually this guy who goes by the name of Steve Schleicher, another private attorney who's joining the government. But we have, she goes through. The judge is like, "Are you sure? Are you really sure? I know you just said that you can't be impartial, but think about it again. Let me frame it another way. Let me just say hypothetically." And she's like, "Judge, I told you 5 times. I can't be impartial. I saw what happened. I want that guy in prison for the rest of my life." She didn't say that, but she might as well have. And the judge really just did everything he could, tried to, and this is what judges do. They want to help you understand the process so that you can make a neutral decision. Obviously, that young woman, I think she sounded young to me, is somebody who is not going to be able to do that. So the prosecutor came back up after the fact and said, "Are you sure? Are you really sure?" Because they wanted her on the jury so bad. They were trying to do everything they could to rehabilitate her. So the judge goes, "Yeah, you know what? I think we've kind of made her come full circle. We've circled back on this thing, and she is now capable of making an independent decision and being fair and impartial." And she just was not having it. So she's out. Speaking of this guy, Steve Schleicher. So we have another private attorney who's joining the government. So they're not using some of their own prosecutors. They're pulling in people from outside. We've got this guy who is serving as the Special Assistant Attorney General on A.G. Ellison's prosecution team in the trial of Derek Chauvin. He's an experienced trial and appellate lawyer. Now, some of these people may be being brought in just because of conflict of interest. A lot of conflicts there. Obviously, Derek Chauvin was an officer, so I don't mean to be glib about it. There's some good reasons why. Steve's notable investigations include security company holding, contract, NFL venue, IP theft, liaison defense counsel for corn seed developer, 65,000 plaintiffs, medical device manufacturer, former federal prosecutor, conducted hundreds of investigations, complex fraud matters, violent crime, organized crime, and the list goes on and on. His education, William Mitchell College of Law. He's also from Duluth, has a BA in criminology and political science. So, that's a little bit more about him. It sounds like he's going to be involved, and you can see what the government is doing. They're sort of segmenting their cases out. So yesterday we heard a lot from Matthew Frank, who was talking about the motions in limine. Then we brought another gentleman in, Sundar, I believe, or Sandeep. I forget his name. I apologize for screwing that name up. But it is important because he was covering the motions in limine this morning. And then this guy came out and was doing jury selection. So they're sort of segmenting their cases out and putting the best players on the field for the best plays. And this guy, Steve Schleicher, he is the first one that I have heard thus far to bring out the racism charge. So racism is already in play now that we are on day 2, and it's in the form of what's called a Batson challenge. What is a Batson challenge? This is an objection to the validity of a peremptory challenge on grounds that the other party used it to exclude a potential juror based on race, ethnicity, or sex. The result of a Batson trial, a challenge may be a new trial, comes from a case called Batson versus Kentucky, which held this type of peremptory challenge to be unconstitutional when used by criminal prosecutors. Another case says that they can do that in civil claims as well. So what does this mean? Well, when you have a jury, when you're paneling a jury, when you're going through voir dire, you have a certain number of strikes. You can strike somebody for cause, like that last woman, right? She said, "I cannot be impartial." No, are you sure? Yeah, I can. I told you 5 times already, Judge. Sorry. So they don't need to come up with a reason to strike her off the panel. She provided one on her own. So the judge can strike her. Anyone can strike her for cause. They say, oh, look, she's said herself she can't be impartial, so she's gone. But there are other situations where you have what are called peremptory challenges, meaning you don't have to provide a reason. You just don't like that person. You say, oh, I didn't like it. I'm not gonna have to articulate it too much. We're just going to strike them off the panel. Now, of course, every single attorney has justifications for every strike, but what we saw, and the reason why this case came about in 1986, is prosecutors were striking people of color. Okay, if a defendant is on a trial, and let's say the defendant is a black male, and you start to see some potential black males go on your jury panel, and you're a prosecutor, you don't really want that to happen, do you? So the allegation in that underlying case and what prompted this Batson challenge is that prosecutors were using their peremptory strikes to get rid of people of color off their jury. If they want to get a conviction on the black guy, they want a jury box that doesn't have any black guys in it, right? And the Batson versus Kentucky case came about. And so today, what we see is the prosecutor is using that rule against the defense. So now Derek Chauvin is on trial. And you could make the reverse argument. Well, maybe he doesn't want black males on the jury. Now, his defense team hasn't said that at all, but the prosecutor is. The prosecutor is saying they are using their peremptory challenges to strike people of color. That's not so good. So the defense attorney then is going to come up and say, that's not what we're doing. Okay, we're striking him for this reason. We have justification for it. It's not a race thing. It's because he said something that we didn't like. And the judge ultimately agrees with the defense again. So this is the attempt to bring up the Batson challenge. And this is our last clip. Then we're going to get into, I know the volume is low today, but
all right, jury number 4 has
I think it's a product of the court's sound system.
Defense indicated they wanted to do a peremptory and the state mounted a Batson challenge.
So the government just struck a witness,
yes, for the
a
record,
juror.
The defense has made its peremptory challenge now on its second person of color in the jury pool, and the state has raised a Batson challenge. And it's clear from the record that the the juror number 4, self-identifies as Hispanic, as did first juror that was struck by the defense. And when asked to provide a race-neutral explanation for the exercise of the peremptory, the defense, and I'll let them speak for themselves, but articulated just sort of a generalized concern that this particular prospective juror expressed strong opinions and articulated a belief that he was simply trying to get on the jury. But there's really no objective evidence of that. There's nothing in what the prospective juror said that would support a conclusion that he held strong beliefs. I believe that the juror said exactly the opposite, and that whatever beliefs or opinions he may have had, he was unequivocally willing to set those opinions aside and judge the case based solely on the evidence, or in his words, on the black and white. And further, expressing the opinion that he would have no problem setting those beliefs aside and deciding the case based on the facts and the evidence and the law. Now, I draw the parallel between juror number 4, who's Hispanic, and juror number 2, who self-identified as Caucasian or white. Their answers with respect to these questions that were raised by defense counsel are markedly similar, if not the same. And the characteristics are very much the same, too. Both expressed a belief that they would decide a case based on the facts and on the evidence. Both described experiences in which they believe they were subjected to some aggressive police conduct when they were younger, but one results in a preemptory strike and the other does not. I understand that the motion from the court has been denied, but I do persist in the challenge.
Mr. Nelson?
All right. So the defense attorney now is going to come up. They're on the fourth juror.
Your Honor, First and foremost, the law requires me to state a race-neutral reason for striking this particular juror. I disagree that the juror did not articulate strongly held opinions. He specifically referenced in his questionnaire illegality of certain moves, certain tactics. He stated that he had formed the opinion that, that these officers had taken the law into their own hands, and that he had formed opinions about what had happened. Yes, this juror indicated that he was willing to re-examine those opinions, but only upon essentially providing him evidence and proof contrary to his opinions, is the way I understood him to say that. I think the difference between this particular juror and the prior juror is that the prior juror had not watched the video. He had limited his intentional exposure. He came at it from a very analytical perspective in terms of science and things of that nature. He had no preconceived opinions whatsoever. That's a significant difference between these jurors. The second reason, Your Honor, is that this juror has a specific training, and I was concerned in part that his training or his belief that in martial arts training that this was an illegal move was concerning, and it struck me as insincere. His statements that he would be willing to re-examine the evidence struck me as insincere.
All right, so the judge ultimately agrees with the defense on this one. The judge said, nope, it didn't seem racist to me. You know, it didn't qualify as a Batson challenge. It was something that, as we just heard, the defense attorney came back out and was very articulate in saying, nope, these are the other reasons why we thought that this person should go. And if you listen to the full clip, the judge comes back out, but he goes on for another 3 minutes, and he says essentially that what the witness was doing, or what the juror was doing, was saying during his testimony that he would be willing to re-examine the evidence. And so you might listen to that and go, well, that sounds pretty fair, but it's re-examine, meaning he's already come to a conclusion that it's not in Derek Chauvin's favor. He's already decided that Derek Chauvin is guilty, but he's open to re-examining the evidence. He'll be fair and impartial on the evidence that's presented in court. Sure, I'll be fair and impartial. I'll listen to new stuff. If new stuff comes up, yeah, I'm happy to change my opinion, but that is shifting the burden onto the defense. Remember, at this moment, Derek Chauvin is innocent. So if that witness would have come forward and said, I do believe he's innocent, and I'm willing to give a fair shake to him and observe any evidence that comes into court, then that's fair game. But if you come in and you say, well, I already think that person is guilty, you're undermining the presumption of innocence, and you're shifting the burden. Now the defense has to prove that Chauvin is not guilty, rather than the government having to prove that he is guilty. And so that is an improper thing to do. It's an improper burden shift. And that is essentially what witness number 4, or juror number 4, was talking about. And the judge said, no, we can't have that. So the Batson challenge went out. When we started the day, we saw that this was our panel. So we're missing some people. Let's start filling it in. We have 3 jurors that we can sort of identify. We can't call them out by name or anything like that. We don't know their names or who they are, but we do have 3 people who are filling these seats. So let's take a look at who they are. Number 1, this article came over from StarTribune.com. They're doing a great job covering all of this. The first seated juror is a white man. And so we have the white person emoji in there. And so this is sort of what I think he might look like. He was selected after being questioned at length by Nelson for a few minutes. He revealed he's a chemist who lives in Minneapolis. He says, I consider myself a pretty logical person. I rely on facts and logic and what's in front of me. Opinion and facts are important distinctions for me. And so we just picked different emojis for these things. He said he has a generally favorable view of Black Lives Matter, because he added, I think all lives matter equally, but that, quote, Blue Lives Matter message among police advocates is a counter viewpoint that isn't necessary. He said he has not viewed the video of George Floyd's death. So he has not viewed it, which means he's probably one of the only people in America that hasn't seen it. After checking with the defense and prosecution, Cahill told the juror to report back on March 29th and be prepared for the proceedings to last about 4 weeks. So people were asking yesterday, how long is this going to take? It's going to take a long time, probably all throughout April. The rest of March, all through April, we're going to be learning more about this. So juror number 1 we see here is somebody who's a chemist, white male, and he's got, I would say, moderate level of support for BLM. Next up, we've got another witness who is a a woman and a person of color, according to this article. The second seated juror, she's a woman and a person of color, originally from northern Minnesota, told Nelson that she was, quote, super excited to receive her jury summons because she realized it's her civic duty. She was eager to serve regardless of the case, but especially in Chauvin's trial, given the gravity of it. A quote from her says, "It's a very important case, not just for Hennepin County, but nationwide. It's just something everyone's heard about, talked about. No matter the decision, people are still going to be talking about it." Like many of the others before her, she said that viewing the video left her with a, quote, somewhat negative impression of Mr. Chauvin. No one wants to see someone die. The woman also says she sees racial disparity in the justice system. In connection with that belief, she added that she agrees somewhat that the Minneapolis police officers at times used too much force against black suspects and has heard of those experiences from people she knows. At the same time, she considers herself to be a go-with-the-flow type, assured both Nelson and the assistant prosecutor, Steve Schleicher, that she can be open-minded about the evidence presented at trial. The woman, the niece of a Brainerd law enforcement officer, was then seated. So that is juror number 2. She was a very interesting a juror when we were hearing her speak. A lot of energy, very dynamic personality, a lot of tonality in her language, and she'll be interesting. We'll see if she ends up being dispositive in this case because of her big personality. Then the third juror who was seated, we don't know as much about. This guy is a man who works as an auditor. And so for the emoji, I just picked somebody who looks like an auditor to me. An old guy with glasses, was chosen for the jury after expressing confidence that he could be fair. He saw at least portions of the off-reference video and somewhat negative view of Chauvin because, quote, someone died and that's obviously not a positive thing. At the same time, the man continued, he said he can examine the evidence from a viewpoint of the law before deciding whether or not the defendant is guilty. So we've got 3 jurors seated. Here is what our panel looks like. So thus far, we've got numbers 1, 2, and 3. We're going to pick back up on jury selection starting tomorrow, and we'll see how much further we can get. We'll see if we can get more than 3, because this morning started out with a lot of the motions in limine, and so we may have more time for jury selection that we'll pick back up literally tomorrow. So we'll start to fill this out and get an idea of what our panel looks like. All right, so let's jump into the questions over to from locals.com. So if you go to watchingthewatchers.locals.com, you can ask a question and it'll show up right here. Let's dive in. We've got News Now Wyoming says, question, you are the defense attorney. Does Chauvin testify to speak against intent for the second-degree murder felony requirement? So I think that Derek Chauvin has to testify in this case. Yeah, people need to hear from him about his training. They need an understanding about what was going through his mind and why he didn't move. I think the jury will convict him unless they hear from him. It's just my opinion. You know, traditionally the rule is your client does not testify, period. All right, they just don't. In this case, I think he probably needs to. We'll see. We'll see what some of the evidence says. Maybe he doesn't, just because of some of the toxicology stuff that we heard yesterday. Still waiting to sort of piece that together. Yesterday, we heard from the defense attorney that they found some residue of drugs and George Floyd's DNA in the back of a police car. I watched the police officer's body camera last night. Didn't really see that, but we'll see. You know, if they have a slam dunk, if they have something in their case, the defense, that they can spike the ball on, then maybe Derek Chauvin doesn't need to testify. But I think he ultimately will. I think the jury needs to hear from him about why he kept his knee on the neck for 8.5 minutes, 8 minutes and 46 seconds. If he doesn't explain that, I think they convict him. We've got JBone86 says, was the 94 crime bill a net positive or negative piece of legislation for minority communities? I would say, guessing here, I'm not in a minority community, but I would say I've represented a lot of people who've been impacted from the 1994 crime bill, along with the 1986 bill, 1984 bill, 1988 bill, many of which grossly impacted minority communities. I think the 1988 crime bill was specifically focused on crack cocaine. Crack cocaine, what community did that impact? Was it suburban white folks? No. It was inner city African-American people. And the penalty there was mandatory prison, first offense. Boom, gone, locked up. So, yeah, I mean, I think if you looked at everything in aggregate, that it is a net negative for minority communities by, I don't know, by a factor of 1 million. You know, it's been really bad. We got mandatory minimums. We got our 3 strikes laws. We've got all sorts of drug crimes and drug laws for marijuana, people incarcerated for possession of narcotic drugs because they had some oil from a vape pen for marijuana. It's THC. It's not even any other narcotic. So it has been a disaster. Yeah. I'm not happy about it. We have Liberty or Death says, why are there private attorneys joining the government? Isn't the AG leading the team? Is it because they want to appear neutral by hiring attorneys from elsewhere? Yeah, I think it could be that. I mean, it could be that they want to just bring in outsiders so that there is no conflict of interest going on. Maybe people in the AG's office have prior experience working with Derek Chauvin. I don't know. Probably some of that, probably because some of these guys are just excellent at what they do, right? We have a Harvard grad and a Yale law graduate. We've got some other guy who's, been a former federal prosecutor. And so they've got a lot of experience and they want to bring in some heavy hitters, but there are probably some other rationales for it. They don't want to sort of, this is taking place in their backyard. They all got to go home at night and they all work together with all of these other people. So I think in theory, they want to bring somebody in from the outside who can help them run the case. Realtor Patty 14 says, why are they trying to change the minds of the jurors? So they're not really trying to change their minds. They're just trying to nudge them back to impartiality. Now, the prosecutor, of course, the defense attorney they're out there trying to lay out the framework of their case. And so this is an important part of criminal law that some people just overlook, even some defense attorneys overlook. But voir dire, when you're going through this, you're not just asking questions just sort of, well, we'll see, we'll just see, I'm just curious. You're establishing the theme of your case. You are going out there and you're saying, listen, every one of these questions should have an intention behind it. They're not just, he's not, the defense attorney today, Eric Nelson, was not just talking about, he asked many prospective jurors about tell me 3 things about yourself that I wouldn't know. If we met at a party, what would you tell me about? Right. And so they would start telling him about stuff. And then he would, that's sort of getting to know the jury, be vulnerable with me. Tell me about you. Okay. I know you. And then he's going to use that in his narrative, in his theme of his case. But he's also asking questions. We saw a lot of this, a repetitive theme from him saying that he was asking them about whether or not they've ever helped settle a conflict before. So have you ever helped 2 people settle a conflict? And they go, yeah, of course I have. Oh, how did you handle that? And so they would say, oh, well, I would go there and I would communicate with both sides and I would get their opinion and I would get their opinion and I'd bring it together and I would synthesize a result. And you go, okay, great. Because further down the line in the case, he's going to be talking about settling a conflict and he wants them to think about that. Okay, if there's 2 people in a conflict, which side is being reasonable, which side is being unreasonable? So he's planting the seed in their minds, in the juror's mind right now. You know how to be reasonable with people. You know how to settle a conflict. How would you handle it? So they can start thinking about their own conflicts in their own minds. Well, here, then the defense is going to show, well, as soon as the government plays the video of George Floyd, they're going to say, okay, yeah, we'll see. They came up to him and said, hey, let's settle this conflict. George Floyd started freaking out. It's going to be their frame on this, right? He's, flailing around. They couldn't do anything else. They tried to settle this like reasonable people. They couldn't. They had to put him on the ground. And so every question that they're asking of the jury, they're just digging that seed in there. So the defense is doing that. The government is doing that. They really tried to rehabilitate witness number 3, the woman who said, no, I can't be impartial at all. And the prosecutor came back out and said, are you sure? You understand that it's easy to get caught up in these things, and he was doing everything he can to sort of move her back towards neutrality. She was already in Convictville. He was trying to bring her back to neutrality land, and she just refused to do that. Now, the judge is always trying to keep people in neutrality land, but really they're not. They're not trying to change their minds. They're just trying to get them to a baseline that is even across the board, which is basically impossible. But this is as good as our system can get, and it's pretty good relative to other things. We got Ma Fox in the house, said these potential jurors seem to be eager to be dismissed from jury duty. Do jurors have to take an oath before voir dire? Yeah, they do. So they do. They swear an oath that everything is truthful. They agree. They're going to let the court know about certain things. Everything on their questionnaire is truthful and accurate and all that stuff. So the judge does that. I think today, I don't recall, I kind of zone out when the judge goes through that stuff. I think today he did it for the entire panel at the start of the session and then sort of just asked them when they were brought up to the bench whether or not they heard that and whether they still agree to it and all that stuff. So potential jurors seem eager to be dismissed from the jury duty. Yeah, I mean, we did see that. I think there were 8 of them today. Most of them are gone. Obviously, we've got 5 who are gone, and then we've got 3 that are on there still. And it's, I mean, think about what is being asked of you to be on this jury, right? You're going to be at least on a panel from March 27th for 4 weeks. So your job, school, family life, all that's a mess. Then you've got potential violence against you. Okay, what if this jury acquits Derek Chauvin? They're going to get doxxed. They're going to get identified. They're going to get death threats. I mean, it's going to be not good. So they got to be thinking about their own personal security and their well-being. Not to mention just the even if they convict him, they're going to be the subject of the spotlight for the foreseeable future. And a lot of people don't want that. They want to live in private, in peace, not be the subject of a national story for criminal justice reform for the foreseeable future. Now, there are those people who are thrilled about it. They're very excited. They want to get on that panel. They're going to write a book about it, start a blog, start a Twitter account. This is their big break. So, like, I think juror number 4 we heard from, she's excited as hell. Yeah, baby, put me on that. I've got some justice to deliver in this country. So good for her. We have Jeremy Matrita says, I'm sure jury selection is a competition between both sides. The defense wants jurors they feel will be objective. The prosecution wants jurors they feel will lean toward convictions. It must be stressful. It is stressful. I've done a handful of them. They are fast paced typically, and you've got a lot of information that you're trying to digest all at once. So it's a skill set I think that you develop with time. But you're right. You're trying to move the needle your direction, one way or the other. And there are entire industries of consultants and people who will help you pick a jury. And there are even apps for that on your iPad and stuff. Download an app so you can say, okay, white male, 35, high school education, Catholic, 2 kids, divorced, had a traffic ticket 100 years ago. All right. You got a nice little profile of that juror, and you want that for all of them. And so it can be a lot of information to digest, and it can be uncomfortable too because you're having to sort of needle people about what they know, and sometimes people don't want to answer that. Hack Consulting says, if the defense has such a blatantly clear reasons to dismiss a potential juror, and the prosecution keeps bringing up the question of racism, while it may be an attempt to keep the defense attorney honest, perhaps the reason why prosecution missed the blatantly clear reasons because they are anti-racist. Yeah, I thought it was way too early to bring out the Batson challenge. They were only on their 4th juror. The first woman, clearly, in my opinion, should not have been on the jury, not because she's Hispanic, because she can't speak English. She just happens to also be Hispanic. So, it was, I think, premature, but you're going to hear that the entirety of this trial. Racism, racism, racism. We hear it all day anyways. All day, everywhere you turn, everything's racist. So why wouldn't we see it in a trial? Hack Consulting says, okay, so second-seated juror wants to do her civic duty. Is it because she wants to put Chauvin into the slammer based on her formed opinions? I mean, I was excited to do my jury duty after I got out of the military that week. They ended up not wanting jurors. And I wanted to go because others tend not to want to, but I would be hesitant to be a juror because I want to be a good one. My civic duty is showing up, not being on the jury. Yeah, and I agree with you on that. I think anybody who's a little bit too eager to get involved in something is kind of the person you don't want there. You sort of hear that analogy like the best emperor of Rome is the person who doesn't want to be the emperor of Rome, right? And that's why you got to do it. Because if somebody wants that position, well, why is that? It's because they've got ulterior motives and selfish reasons for wanting that position of power, which is the same argument that you could apply to any elected politician in this country. So if somebody's really eager to get on a jury, it's like, well, why? Why? You're excited about it or what? Because this is not something to be excited about. This is a tragedy what happened here. This is a tragedy across the board. It's not anything to be excited about. We have a dead man and somebody whose life, and multiple people whose lives are ruined as a result of it. You can say he deserves it or not, but it's ruined, right? One way or the other. If he's convicted, it's ruined. If he's not convicted, it's still ruined. Him, the other officers, George Floyd's family. I think George Floyd had kids. It's just awful. I don't know what being excited is about, but some people live those types of lives where this is interesting. News Now Wyoming said, I had the same opinion about his need to testify, but it is interesting to see a defense attorney share the same opinion on the need to break the rule about testifying in your own trial. Yeah, it is relevant. I think that in cases like this, in most cases, you don't want your client to testify because they're not really good at testifying, right? They're just not. You can train them. You can go through the process. They're just terrible at it. Derek Chauvin, though, is an officer. He's been an officer for a long time. He's very used to testifying. He's trained in it. He's probably testified in hundreds of trials. So he's very good at it. He knows what to do. He knows how this whole game works. And so he's not your typical witness. He is somebody who's got a lot of experience in this. And because it was his knee on the back of George Floyd's neck, I think that he has to explain that. He's the only person who can do that. So I think they got to put him up there. Now that I think about it, I think he has to get put up there. Liberty or Death says, if I get called for jury duty, can I use the excuse that I will miss my finals if I have to sit on the jury? I would tell a judge that, but I don't know what the judge is going to say, right? Maybe he'll commiserate with you. Maybe he'll say, well, yeah, I had to go to law school too. So you're excused there, Liberty or Death. Or maybe he'll say, just call your professor. Tell him, if you sit in my trial, you should get credit for that and not take the final exam. Use some negotiation powers. See if you can kill two birds with one stone. Get some good jury duty experience. Don't have to take a final. Well, there you go. All right. So those were great questions over from locals.com/watchingthewatchers or watchingthewatchers.locals.com. Nice, awesome community over there. I want to invite you to go join us. All right. So that's it for the Chauvin trial.